us this morning is In Re IKW. Each party will have 15 minutes up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve any time for rebuttal, if you let me know, I'm keeping track of the clock, and hopefully you can also do so on the screen up there. Please do not use the names of children, any minors, victims in this case. Refer to them either as by initials or by victim or child or whatever is easier. We have read your briefs and we're ready to see when you are.
Thank you, Your Honor. Your Honor, may it please the court, Attorney Nicholas Klemenko on behalf of the appellant, mother Sherry Kozlowski. I'd like to reserve 1 minute for rebuttal purposes. There are 4 assignments of error in this case. I'm going to begin with assignments of errors 4, 3 that are in direct response to this appellate magistrate's order on March 22nd, 2019. On October 3rd, 2017, the trial court entered a legally insufficient fake stipulation of dependency at the adjudicatory hearing and did not follow the mandates of Juvenile Rule 29E. The complaint of the parties was stipulated to, was peppered with mutually exclusive positions of the parties. The complaint was filled with 8 lines of physical injury findings by Rainbow Babies, where the child alleged father to be the cause thereof, the child's multiple, graphic, sexual abuse disclosures against father, father's denial that he sexually abused the child, father's position that mother created a false belief in the child, therefore coaching her child, in which I would remind appellee that this position is conditioned upon mother supporting her child's sexual abuse disclosures. Once mother heard that the child's disclosures, in the complaint it states that she immediately took the child to Rainbow Babies. It's a clear indication that mother believed in her child's statements and reacted upon that belief. Lastly, father admits that his child made sexual abuse disclosures to multiple medical professionals. This is a repeat of the previous case in 2015, which facts thereof were incorporated into the 2017 complaint. The case history, mother's actions, father's addendum to the complaint show views that are diametrically opposed to one another. The language of Juvenile Rule 29E is plain. It's unambiguous, and most of all, it is mandatory. Juvenile Rule 29E states that if a party denies allegations, the court shall direct the state's prosecuting attorney to prove that complaint by clear and convincing evidence. Here, father denied the allegations. If father did not add the addendum to the complaint in which he denied the allegations, the court could have taken a proper stipulated complaint. The first sentence of father's addendum reads, father, Robert Whittle, denies that he sexually abused his daughter. Father's addendum goes on to state that his daughter believes that she was sexually abused. Mother believes her daughter was sexually abused. Father believes mother is coaching. These are mutually exclusive factual scenarios and cannot be disguised as a stipulation, therefore invoking Juvenile Rule 29F1, which further mandates the courts that if the allegations of the complaint were not proven, to dismiss the adjudicatory complaint. Since the allegations of the complaint were not stipulated to, since the state did not prove the allegations thereof, then the finding is void and should not have proceeded to disposition. As a result, these hearings were not properly bifurcated. In juvenile dependency cases, direct bifurcation of the adjudicatory and dispositional hearings cannot be waived. Equal to this right that cannot be waived is the constitutional protection afforded to parents defined as the fundamental interest in the care, custody, and management of their children. which have been incorporated into the statutes and rules governing juvenile law. In particular, Revised Code 2151.28L specifically incorporates these rights for when the juvenile court adjudicates a child dependent. It is mandatory that the court issue written findings of fact to include specific findings as to the existence of any danger to the child and any underlying family problems that are a basis for the child's determination that the child is dependent. Why is this important? This statute is intended to protect the due process rights of parents. And without placing these findings in the October 3rd, 2017 adjudicatory order, mother was not provided notice of the dangers that were required pursuant to Revised Code 2151.28L. As a result, the hearings again were not legally bifurcated due to the fact that mother was required to be notified of these findings prior to the dispositional order. Absent the required findings in the adjudicatory order, the dangers of the complaint still existed, and mother was not provided adequate notice thereof to form an objection, which is the purpose of providing parties notice. The deviation of these statutory mandates is an abuse of discretion, requires reversal and dismissal of the complaint. Pursuant to appellate mother's second argument on appeal, the trial court had abused its discretion in ordering a vague parenting time schedule, which denies mother her reasonable right to visitation and ability to use her mental health treatment in an effort to extend that reasonable right to visitation. In In Re KD ND, 9th District 2017 case, the Summit County Juvenile Court awarded legal custody to father. The court ordered that the mother have regular supervised visitation as the parties agreed. If the parties could not agree, mother was permitted to receive at least 1 hour of visitation to occur at a neutral site, to be supervised by an appropriate adult besides father. This court held that that order was too vague to offer mother any certainty with regard to her statutory privilege of her reasonable right to visitation. Well, this makes sense, because in custody cases, the parties will disagree. In this case, the trial court ordered mother to receive up to 4 hours of supervised parenting time every Saturday at a licensed visitation center. Further, the court will reconsider mother's visitation once she engages in intensive therapy as recommended by the magistrate. Here, the trial judge's order does not define the time in which mother is to receive parenting time. The order does not specify where it will occur. Is this a visitation center in Lucas County? Is this a visitation center in Summit County? Is this a visitation in somewhere in between? And if the parties cannot agree, what happens? More importantly, what is intensive therapy? It is important that these orders are definite, as the parties have a contentious history and are diametrically opposed to one another. Such vague orders do not protect mother's privilege of reasonable visitation, as it does not direct the parties to do or not to do if they enter into a disagreement. More importantly, Your Honors, it provides mother no remedy if she is not able to see her child, because she cannot file a contempt based on this order, because it really doesn't direct the parties to do one thing or not to do one thing. Mother is left in somewhat of a no man's land if father decides not to agree. These vague parenting orders in domestic and juvenile cases are a problem. Instead of a party who loses custody getting the residual right to parenting time, it acts as a de facto permanent custody order, giving the custodian sole discretion in a hearing where the burden of proof is by a preponderance of the evidence instead of clear and convincing at a permanent custody trial. Further, the trial court directs that the court will reconsider mother's visitation once she engages in intensive therapy as recommended by the magistrate. The magistrate's order is further ambiguous in that it states that mother should not have unsupervised visits until she attends intensive psychotherapy with a proven treatment plan. The duration of this attendance is up for question. The definition of what intensive psychotherapy is up for question. Proven treatment plan. Anybody reading that, most importantly mother, cannot understand what that is. And what that does is it sets mother up for failure. Mother, for instance, mother can attend months of counseling at Summit Psychological, show up to court, and the trial judge say, well, I see that you're being treated, but I would have liked somebody who has treated this this specific issue with about 10 patients or more. The fact that your counselor has only treated 1 or 2 people like this doesn't sit well with me.
Is there anything that would preclude mother from providing that information to the court before she started that counseling with a particular counselor?
Not prior.
Ruled by the court ahead of time?
Not prior to her receiving this order. So once mother receives this order from the magistrate, for instance, her attorney can say, hey, get into counseling right away. Let's start the ball on this. And we're going based on what those orders are. So we file the objection. It stays the order. We're months into the case. And in between that order and let's say us going back to court for the purposes of a review hearing, that's months of time. And that's months of time that are wasted if mother does that intensive psychotherapy that she doesn't even know how to follow, and there's no recommendations thereof. That's months of time wasted. And that is the issue that we are presenting to the court. It is to correct these vague orders in parenting cases, or in domestic and the juvenile cases. And that is the policy behind the second argument that mother has presented. It can additionally pose problems too because the frequency in which she is to receive counseling is not stated in the order. The order has too many unknowns, and it sets mother up for failure, and it diminishes her ability to argue custody by citing case plan compliance with her mental health treatment. If her case plan compliance is not adequately defined, such as in an order like this, and she shows up to court, then what's the purpose of these orders if they're not good enough, if the court's not going to abide by them? Lastly, Your Honor, going to our first assignment of error, we argue that the trial court committed an abuse of discretion in upholding the magistrate's order as it was against the manifest weight of the evidence thereof pertaining to the best interest of the child, and ordering that the child be placed in the temporary custody of her father. And that argument is very extensive. I believe the brief which I wrote speaks for itself, but in particular, that case had many facts that were not accounted for by the judge. And father presented 2 experts at the hearing, which actually we believe helped mother in her position, whereas father's experts identify that 95% of sexual abuse cases do not have physical findings. This was a case where there were no physical findings. However, that is consistent with what happened in 2015 when the court adjudicated the child as dependent and continued to place the child in the temporary custody of mother. There were no physical findings in that case. Father's other expert testified that 85% of children who disclose sexual abuse disclose to their mother.
And Counselor, we're just now reaching that 1 minute mark.
Your Honor, I'd like to go ahead and
Sure.
pause at that time and wait for rebuttal. Thank you.
Good morning, Your Honors. Andrew Whitaker, on behalf of the appellate. Before I begin, I wanted to make a point of clarification. This court's March 22nd order requesting the supplemental briefing indicated on its last page that this matter is set for oral argument on this issue on April 30th, 2019. So it's my understanding that the oral argument today relates solely to the issue that this court requested be briefed in its March 22nd order.
Thank you, counsel.
So I will address that. If I have extra time, I will move on. First, I'd like to note that Children's Services is not here. They've waived oral argument, and they are in support of father's position regarding the magistrate's ruling, the trial court's adoption of that ruling. There's 3 issues here for this court based on its March 22nd request for briefing. The first is, were there specific findings that can be relied upon by the magistrate to find dependency in its adjudication? The second is, were those findings necessary? And the third is, if those findings were not there, but were necessary, was the right to those findings properly waived by the parties? And I think the answer to all 3 of those results in this court affirming the trial court's adoption of the magistrate's adjudicatory decision. The magistrate adopted the factual assertions and found dependency. There was no finding that, there was no allegation in the complaint by Children's Services or mother that father sexually abused the minor. So if a very careful reading of the amended complaint, which was the factual findings adopted by the magistrate in the adjudication attached, which the parties jointly supplemented to this court, indicates that there is no allegation by Children's Services that the minor child was in fact sexually abused by her father. The factual allegations are the fact of the prior adjudication, which did not find that father had sexually abused the minor, a statement that the Rainbow Hospital did not find physical evidence of sexual abuse, and the only allegation regarding the basis for the minor child's statements is the last page of the amended complaint, where father alleges that the basis for the minor statements was mother's coaching. And it also details the testimony, the belief of father's experts about why those statements were made. At that point, the magistrate had adopted factual findings, no portion of which alleged that Mr. Whittle actually sexually abused his daughter. So the court's March order that talked about inconsistent findings and a joint adjudication disposition ruling is, upon a thorough review of the magistrate's decision, inaccurate, because there were not inconsistent positions. Children's Services complaint, as agreed to by all the parties, did not make an allegation that Mr. Whittle in fact sexually abused his daughter. So I believe that the factual basis for the adjudication is clearly laid out, and it is not contradictory. The factual allegations the magistrate adopted do not contain a contradictory statement from Children's Services and father about whether or not the minor child was abused. And mother agreed to that. This is a windfall for mother, that she has an opportunity now to object to an adjudication she never objected to. She agreed with the statements in there. Even if this court were to find that the factual allegations contained in the amended complaint adopted by the magistrate did contain an allegation by Children's Services that the minor child was sexually abused, then the factual allegations in there contain the environment, the statement, the underlying family problem as a basis for dependency, pursuant to Division C. That basis is very clearly the minor child has a mother who is alleging abuse by the father is denying it, and the child is stuck in the middle. So even if there were contradictory allegations in the amended complaint, which we don't believe there were, I believe that that is an underlying family basis upon which the magistrate could find dependency. The second prong is, were those findings necessary? Did the magistrate need to adopt those factual conclusions that he did in the complaint? And I believe that the statute indicates that they were not. 2151-28L provides that if the court at an adjudicatory hearing held pursuant to Division A of this section, that's the scenario in which the court must find the factual findings and conclusions of law to find dependency under Division C. That is not what we have here. We have a stipulation. The parties did not move to an adjudicatory hearing. If the legislator had wanted these findings and facts and conclusions of law to be indicated in every ruling finding dependency, that's how the statute would have read. The statute would have required, upon a finding of dependency, the magistrate must indicate the facts and the basis. But that's not how the statute reads. The statute reads only upon an adjudicatory hearing held pursuant to Division A of this statute. And so it is only upon a contested hearing is the magistrate required to indicate the factual basis. And that's consistent with the case law cited by this court in its March entry. In both of those cases, an adjudicatory hearing was held. While one of the parents stipulated to a finding in one of the cases, the other parent was incarcerated. So there was a hearing held. Children's Services put facts on the record, and the magistrate was required to make a finding based on the evidence presented. In this case, there was no hearing held. The magistrate underwent a very thorough review of the trial court's waiver of the trial rights for the adjudication. Those were signed as well as discussed on the record. Both parties were represented by competent counsel of their choice. So there was very clearly not a hearing, and the fact that that hearing was waived is very clear on the record. And I guess that's a kind of a backdoor to my third prong, and that is that if the findings of facts were required, was the right to that finding of fact waived by the parties? And the answer to that is unequivocally yes. The appellant is arguing now that she's been denied her constitutional rights to due process by the magistrate adopting a ruling that she specifically agreed to. The record reveals that the parties arrived prepared to move forward to adjudication. There was a break. They consulted with counsel. They came back in the room. The magistrate thoroughly reviewed the rights that were being waived. And let's remember, the juvenile rules and the Ohio Revised Code allow parties to waive the most sacred rights. They can waive termination of their parental rights as long as the court determines that that waiver is knowing and voluntary. And that is what happened here. Again, the parties consulted with competent counsel of their choice. The magistrate had them sign a paper waiver, which was filed in the trial court, and took the additional step to review that on the record with the parties.
Can they waive those rights in adjudication?
Yes, they can. And it happens every day in juvenile court.
Is there something specific in this particular record which shows that they are waiving their right to a separate dispositional hearing?
The review of the transcript indicates that they are waiving the right to the adjudication, and then the parties move forward to a disposition. There are two clear and separate orders. On the first order, which is the adjudication order, that's where the magistrate adopts the factual allegations in the amended complaint. And that is the ruling on the adjudication which the parties waived. Then the parties moved forward to a disposition, and the hearing was held on that, and there was a separate dispositional ruling. So there wasn't a joint adjudicatory dispositional hearing or ruling here.
And the court, in that dispositional order, the magistrate ordered protective supervision to the agency. Was the agency seeking protective supervision?
The agency was seeking protective supervision. At the end of the disposition, the parties all, after the evidence was presented, the agency was seeking protective supervision regardless of whether or not the child was placed with mother or with father, because they thought it would be in the child's best interest to continue to monitor her regardless of where the magistrate put her. So yes, they were looking for supervision, and that's what the GAL recommended as well.
So in looking at the amended complaint, that apparently was July 31st, 2017,
Yes,
the abuse stuff is all lined out, so abuse is not something that's a part of this case. Dependency, the only thing that's checked is C.
yes,
So the only thing that this case went forward under was 215104C.
yes, Your Honor.
That's it.
That's it.
Okay. And then the narrative, the following information contains the factual basis for this complaint. All that stuff that's in there is still in the complaint, and also father's statement is still in the complaint.
Right, but what's important is that this is an amended complaint, so the certain allegations are removed.
Okay,
Yes,
okay, thank you.
so those are the allegations, and those are the factual allegations upon which the magistrate made a determination of dependency under Division C. I will move to the remainder of the appeal in case I was incorrect about the subject of today's oral argument. And I think that the record is replete with a factual and legal basis for the trial court's upholding of the magistrate's decision. The trial court in this case did an extremely thorough review of the evidence and the transcript. It was an extremely lengthy trial court opinion, as she did an independent analysis of both the magistrate's decision as well as the evidence presented in the disposition. And again, going back to that initial issue, mother had the ability to object to the adjudication. She chose only to file an objection and an appeal based upon the dispositional ruling. So beyond the knowing and voluntary waiver in court, she at some point still had the opportunity to object to the adjudicatory finding, and she chose not to do that. This appeal presented to this court is only based upon the dispositional ruling. And I think that the trial court's reliance on the magistrate's decision is, again, firmly rooted in facts and firmly rooted in the law. The appellant discusses some of the things that the minor child said, statements she made. It's important to note, as the magistrate and the trial court did, that the minor child made allegations of many, many individuals touching her and assaulting her. It's important to note that many of the critical allegations relating to father happened at important points and junctures in the case before Children's Services, and the guardian ad litem testified to that at the dispositional hearing. It's also important to note no charges were ever filed against Mr. Whittle, despite these allegations. And in fact, there was much discussion in the hearing about the fact that there had been continued allegations by mother, and Children's Services did not file a new complaint until they got the medical records from University Hospital in Cleveland. And upon receipt of those records, father immediately contacted a child abuse expert from Michigan, a doctor whose job it is to protect children. He works with the same nurses, he works with the child abuse, and he looked at the medical records and immediately contacted Mr. Whittle's attorney, which is in the record, and said, have the hospital look again. There's no evidence of sexual abuse. And that's in fact what University Hospital did. That's why those allegations are taken out of the complaint, and that's why Children's Services did not call a single witness from University Hospital at the disposition. The other expert that father identified and had testified at the adjudication, at the disposition, was Dr. London, whose primary job and research is centered on how can we create interview techniques so that we can rely upon children. Her research is not based on how to distrust children. Her job, her research, what she's done for over 20 years, is to figure out how we can come up with techniques so that children can be trusted and children can be relied on. And what she testified to here is in her many, many years of research and study, she's never seen a child subjected to the physical or interview or counseling that she has here. Over 92.
Thank you, Counsel.
Thank you, Your Honor.
Dr. London, Dr. Girton never met with the child. They never spoke with the child. But who did? Counselor Gomez, who has practiced for 11 years and testified that she had never counseled a child who has lied about this specific issue, and that there was nothing to indicate that this child was lying. The fact that the child, in the complaint, the child has made multiple sexual abuse disclosures about father. That is correct. Parents in juvenile custody hearings can waive certain rights if they are apprised to these rights. The juvenile court did not ask mother if she wanted to waive juvenile rule 29E. The juvenile court did not ask mother if she wanted to waive Ohio Revised Code 2151.28L. You cannot waive rights that you have not been apprised of, and you cannot waive the right to bifurcate these hearings, and you cannot waive your constitutional right to notice, to object to certain orders if they are absent from the record.
Thank you,
Thank you.
Counsel. Thank you both for your arguments today. The court will take the matter under advisement. We will issue a written decision which we mail to all parties as well as posted on the Ohio Supreme